It's been almost 100 years since the federal government imposed strict limits on a device designed to muffle gunfire. If these legal challenges succeed, you might never have to register your suppressor or short-barreled rifle again. A significant legal battle has been launched against the so-called silencer or suppressor prohibition. This follows the Trump DOJ's recent decision to shift their stance on suppressors, concluding that these devices are indeed protected arms. By removing the excise tax on these products, the One Big Beautiful Bill represents a crucial move toward our ultimate objective of dismantling the NFA once and for all. But now is not the moment to ease up. It's the moment to push harder. I mean, the Second Amendment couldn't be more explicit. Our founding fathers couldn't have been more direct. The federal government just acknowledged that suppressors are shielded by the Second Amendment, then immediately claimed they can still regulate them regardless. What unfolded next in the courtroom caught everyone off guard, and it could transform gun rights across America permanently. Here's the situation. There's a case currently speeding toward the Supreme Court involving one of the most disputed items governed by the National Firearms Act, suppressors. And the reason this case carries such weight isn't merely because of suppressors themselves, it's because of the legal reasoning the courts are employing to defend keeping the NFA in place. A reasoning that, if it survives, could provide the government a roadmap to restrict virtually any firearm or accessory immediately. And that should alarm every gun owner nationwide. Let me guide you through how we arrived here, because the developments in this case are truly remarkable. The case is titled United States versus Peterson. It began in 2022 when federal and state authorities carried out warrants at a man's property in Louisiana. We're discussing ATF agents, approximately 50 officers in total, all converging on this individual's property. There were accusations connected to his firearms business operations, but the Second Amendment question central to this case boils down to one solitary object, a solvent trap that was classified as a suppressor under the NFA. One object. That's what this entire constitutional conflict centers on. Mr. Peterson filed to dismiss the suppressor charge based on Second Amendment protections. The district court rejected that filing, and the case advanced to the Fifth Circuit Court of Appeals. And while it eliminated the Tommy gun, the legislation also imposed strict limits on a device meant to quiet gunfire. Firearms dealers are noting a spike in silencer sales since January 4th. This is a substantial lawsuit that will send shockwaves through the Second Amendment community, including the National Firearms Act. I'm referring to a genuine legal opportunity that emerged when Congress eliminated the previous NFA tax. However, the Trump DOJ maintains that the NFA's limitations on suppressors don't infringe upon the Second Amendment. Cutting the tax to $0 is progress, but not the victory citizens merit. Now, the Fifth Circuit ranks among the most influential appellate courts in the nation regarding gun rights, and initially, a 3-judge panel ruled in favor of the government, which was functioning under the Biden administration's Department of Justice at that time. That initial panel determined that suppressors aren't arms under the Second Amendment and consequently receive zero constitutional safeguards. That was a crushing decision for suppressor rights and for the wider understanding of the Second Amendment. But then, circumstances shifted. The Trump administration assumed control of the DOJ, and the new Department of Justice executed a dramatic reversal. They actually admitted that suppressors are indeed protected arms under the Second Amendment. Consider the weight of that for a moment. The federal government's own attorneys entered the courtroom and stated, yes, suppressors are arms, and yes, the Second Amendment encompasses them. That represents a monumental change in the government's legal strategy, and it compelled the Fifth Circuit to completely retract its original ruling. Now, here's where matters become truly fascinating. And here's where the worry begins. The panel returned to reassess the case considering the DOJ's revised position. You might assume that if the government itself declares suppressors are protected arms, the court would invalidate the NFA restrictions, but that's precisely what failed to occur. Instead, the Fifth Circuit delivered a fresh ruling that sustained the NFA, but based on entirely alternative justifications. And the logic they utilized is what renders this case so threatening for gun owners everywhere. The Fifth Circuit determined that even if suppressors are constitutionally protected arms, the NFA's regulatory structure withstands constitutional examination under the Supreme Court's Bruen decision. Their logic proceeds thus. The NFA suppressor system functions essentially as a shall-issue permit scheme. You submit the tax payment, You provide your fingerprints, you clear a background screening, you record the item, and, provided you satisfy the objective standards, you receive authorization. Now, upon review, the court rejected his motion to dismiss the charges, prompting Mr. Peterson to appeal to the Fifth Circuit initially. A provision in what's been called the Big Beautiful Bill would eliminate those restrictions as gun rights supporters celebrate and gun safety organizations raise concerns. But, and this is the struggle, the authorities preserved the registration requirement intact. Indeed, taxes, registration mandates for all those products would be eliminated under the One Big Beautiful Bill. The Vice President votes yes. The legislation, as modified, passes. We all recognize the NFA was absurd from the start, a leftover from nearly a century past. The court declared that's practically identical to a shall-issue concealed carry permit, which Justice Kavanaugh indicated in his Bruen concurrence might be constitutionally acceptable. Now, absorb that for a moment, because this is the section that should make every gun owner extremely vigilant. The Fifth Circuit simply borrowed language from Bruen, a case concerning concealed carry permits, and applied it to the NFA structure. They're claiming that provided the government frames its restrictions around objective standards, it can regulate even constitutionally protected arms through a permitting mechanism, a staggering expansion of what Bruen's shall-issue language was ever designed to encompass. And if that reasoning holds, it impacts more than just suppressors. It impacts short-barreled rifles. It impacts short-barreled shotguns. It could potentially impact any firearm or accessory the government chooses to process through a comparable regulatory framework. Simply establish an objective permitting mechanism, attach a tax, demand some documentation, and instantly the restriction becomes constitutional. That is the gateway this ruling creates. Translation: the revenue collection is finished. You won't submit the $200 tax following the effective date. In 16 of those states, it's a felony. It's an offense. It's prohibited material. It's unlawful to own suppressors. The Fifth Circuit three-judge panel determined that the NFA can govern suppressors since the process functions as a shall-issue permit, with the Fifth Circuit Court of Appeals taking a highly unusual action and retracting a ruling concerning these rights shall not be infringed. The reality that they're taxing these short barrels constitutes an infringement upon our Second Amendment rights. The filing also continues and contends that suppressors are naturally in widespread use. After the panel released this new ruling, Mr. Peterson requested what's termed en banc review, meaning he petitioned the full Fifth Circuit, all the judges, to reconsider the case. The Fifth Circuit rejected en banc review, but they didn't halt there. They proceeded further and issued the mandate, which effectively means the ruling takes complete effect immediately. That's not merely a procedural detail that carries genuine, life-changing implications for Mr. Peterson personally. Here's the reason. If the mandate takes effect, Mr. Peterson could potentially be compelled to surrender to prison even while he's actively pursuing Supreme Court review. He informed the court directly that he planned to advance this case to the Supreme Court. He submitted an unopposed motion to stay the mandate, meaning to suspend it from taking effect while he prepares his petition. And here's the surprising element. Even the Trump DOJ didn't challenge that stay. The government's own attorneys were agreeable to delaying the mandate. They understood the effect it would have on this individual's life and freedom, but the Fifth Circuit rejected the stay regardless. The order was direct. It merely stated the unopposed motion to stay issuance of the mandate pending surgery is denied. No justification, no rationale, simply denied. The court was prepared to allow this decision to take complete effect and subject a man to incarceration, even though his case was actively proceeding to the highest court in the nation, and even though the opposing side didn't object to a delay. That reveals something about where at least some of these judges position themselves regarding the principle that any permit system limiting a right might be permitted, provided it functions objectively under the Supreme Court's existing standard. The government must demonstrate historical tradition of comparable restrictions. After all, the National Firearms Act is merely a tax mechanism. It's literally just a tax verification that you owned this firearm before the prohibition was implemented. Now, that wording has been completely stripped from the Senate legislation. If an arm, or something that's necessarily connected with the use of arms, is in widespread use, it's protected. Now, fortunately, the narrative doesn't conclude there. The district court, the lower trial court, intervened and permitted Mr. Peterson to stay free on bond while he prepares his Supreme Court petition, so he'll remain a free man throughout this process, which is the appropriate result. But the Fifth Circuit's unwillingness to suspend its own mandate is meaningful. It communicates something about how seriously, or rather, how casually, that court regarded the stakes involved for this person and for the wider constitutional issues at hand. So, where does this position us currently? Mr. Peterson has until approximately March 9th to submit his petition for certiorari with the Supreme Court. That means in mere weeks, a critical suppressor and NFA challenge will arrive on the desks of the 9 justices. And this petition distinguishes itself from previous efforts to secure the court's attention on suppressors or the NFA. This one is constructed specifically around Bruen. It asks the Supreme Court to determine whether the shall issue permit language from Bruen can be expanded to encompass regulatory frameworks like the NFA. It compels the court to define the limits of its own precedent, and the stakes couldn't be more significant. For Mr. Peterson individually, a defeat means substantial prison time. For the rest of us, a defeat, or even a decline by the court to consider the case, means the Fifth Circuit's framework remains, and that framework states the government can restrict any protected arm provided it dresses those restrictions in the garb of an objective, permitting mechanism. That carries consequences well beyond suppressors. It could transform how courts assess firearms regulations across the country. No more $200 tax stamp on suppressors and short-barreled rifles. Indeed, you heard correctly. One aspect, which is the most significant negative, is the NFA remains intact, and the prospect of a new law still doesn't render it adequate. I mean, we're still discussing prohibitions on some of the most widely owned and popular firearms in the nation. Mario contends that the panel improperly compared the interface taxation scheme for suppressors to something resembling a shall-issue CCW licensing structure. Conversely, if the Supreme Court accepts this case and rules that the NFA cannot merely be repackaged as a shall-issue permit to withstand constitutional challenge, that would be a seismic event in Second Amendment jurisprudence. It would challenge the entire foundation of the NFA and could unlock opportunities for additional challenges against restrictions on suppressors, short-barreled rifles, and other items that millions of Americans seek legal access to without the present bureaucratic and economic obstacles. This represents one of those instances where the legal terrain is truly suspended in uncertainty. The coming weeks will decide whether the Supreme Court intervenes or permits the Fifth Circuit's reasoning to stand uncontested. In either scenario, the result will reverberate through Second Amendment law for years, potentially generations to come. So monitor this case closely as soon as the petition is submitted. And as soon as there are any developments from the Supreme Court, we will analyze everything right here. This battle is far from concluded, and what unfolds next could shape the future of firearms liberty in this nation.